Hello, I'm Daniel Horowitz, an attorney in Lafayette, California. People have asked me, what are the actual steps that get you to a jury trial when you've been arrested and charged with a serious crime, a felony? Well, it's not as simple as it seems to be. You don't just get arrested, go to court, and set a trial date. There are two steps in California, and this is similar to what goes on in most states and in the federal courts. First, you get arrested. Hopefully, you can bail out. But in any case, you're brought to court, enter a plea of guilty or not guilty. That's not the end of that process, because a judge, somebody objective, has to look at what the police and the prosecutor have done, which is charge you with a crime. Are you potentially guilty of the crime? A judge has to decide. There's either a preliminary hearing, which is an actual procedure in front of a judge, where the judge decides, is there enough evidence to suspect that you've committed a crime? Or alternatively, a group of citizens, which we call a grand jury, sits around in a secret room, no defense attorney, and they hear evidence presented only by a prosecutor, and boom, they almost always rubber stamp the arrest and charges. But that's phase one. You're not actually technically charged with a crime in phase one. You're arrested and charges are pending, although for all intents and purposes, you're charged with a crime. It's when that stamp of approval from a grand jury, which can come before your arrest, by the way, or from a judge, which comes after the arrest through a preliminary hearing. Then you go to the next stage. You plead guilty and not guilty again. It seems like Groundhog Day all over again. But then there's no probable cause hearing, no attempt to find out whether or not you're guilty. Instead, at that phase, what happens is a trial date is set. Now, in between the guilty, not guilty, and the trial date, or even the guilty, not guilty, and that first stage, the preliminary hearing stage, there are all sorts of motions, demands for discovery, give me documents, that's what discovery means, or videos, or tell me what witnesses said. All of that goes on. There's lots of battles before trial. And finally, in California, for example, after you've pled guilty or not guilty the second time, if you plead guilty, then you just are convicted. But if you plead not guilty the second time, they've got 60 days to bring you to trial unless you, quote, waive time and give up your right to that speedy trial because you need more time to prepare. So that's the process. Arrest and a preliminary hearing holding you to answer, they call it, and then you plead guilty again, or not guilty again, rather, and then you set a trial date. Or an indictment by a grand jury, which is the same thing as the probable cause hearing by a judge, in which case you skip that first phase and go immediately to the second phase. A little bit complicated, but there are two phases: arrest and a probable cause assessment, or a probable cause assessment by grand jury, and then arrest. And then phase two, the real, I'm charged with a crime, when can I have a trial, are there any motions I can make, and so on. So that's how it works.